It is. Good morning, everyone, and welcome to the session on trustee duties and responsibilities. So we're just going to dive straight in and talk about who is a charity trustee. So what we're talking about here, there's lots of different names for it, but basically it's the same people that we're talking about in most situations. So it's the governing body. It's the people who have the general control and manage the charity's administration and affairs and that kind of thing, who generally have the responsibility for the direction of the charity. So they can be referred to as lots of different things. So depending on what law you are adhering to, you might have a charity that has a board of directors, which are also a board of trustees. And that is because, say, if you're a charitable company, you are bound under company law and charity law. So you would be referred to as both, but it's the same people. On one occasion, or maybe more than one occasion, I had a charity who didn't know that they would be one and the same, and they had both when they shouldn't have. So they had two boards. They had a board of directors and a board of trustees when they shouldn't have, because the board of directors become the board of trustees. And it's just the reference to the familiar kind of terms in under the different jurisdictions that's what we're talking about here. But it may be called a management committee, board of trustees, executive committee. There's lots of weird and wonderful terms, but it's really what we're talking about here. When we're talking under charity law, we are talking about the board, and they are charity trustees. But what the charity trustees are primarily responsible for is the strategic and the financial control and all of the decision making that goes around that as well. So it's a key role. So you need to be aware of what your responsibilities are before you sign up to it. And if you're ready on and you haven't received an induction, this is the perfect example, this workshop, in getting to know what it is that you need to be responsible for. So the methods of appointing trustees, they're usually, it depends on the type of structure that you've got within your charity. So you might be elected or appointed by the members if you have a membership, and that might be done at general meeting or any other time during the year. So that is quite a kind of old school way of doing it, but still lots of two-tier charities decide that that's what they still want to do. And it's kind of ingrained within charity law and company law as well, actually, that the trustees are appointed from this wider membership to run the affairs of the organisation, because there might be multiple members and that wouldn't be feasible to have all of those members dealing with the affairs of the charity in that way. But the old AGM appointment seconding thing is quite old school, so you don't have to do those things if you don't want to. You can have different ways of doing that, and that'll be contained within your governing document. But that's where people come from. And if you have a charity where you don't have a membership and the membership is within the trustee board, just like we talked about last time for everyone who was here last time, but you can also be chosen or asked or invited onto the board as well by the existing trustees. And that can be done in a single tier situation where you just find skills and experience that you need, find someone who has that and ask them on, and then they join in a much more straightforward way. Also, you can be co-opted. So anyone who's got a two-tier organisation or is planning to be a community-led for community asset transfer, then you may wish to have co-opted trustees. And that term, basically that means is that you are finding your charity trustees from out with your membership. So again, it's about that skills and experience and looking at who you might need. And if it's not contained within the membership, then you might need to co-opt. Basically, that just means that you're picking them out. They're not from the membership. They're not from the geographical area that you're hoping to benefit. They are just coming from out with the membership, and they're co-opted onto the board in that way. There's no difference between a co-opted trustee and a member trustee. They're exactly the same. It's just where they come from is different. But once you're on a trustee board, you're bound by charity law, company law, whatever other law that's about. And that needs to, be recognised. The co-opted ones don't have any less authority or less power. Everybody's equal. It's just where they come from is slightly different. Also, some constitutions might have someone that's appointed from an outward body, an external body. It could be a local authority from, some traditional charities, or it could be from a governing body, or somebody like that. An external organisation might have. You might have something in your governing document to do that. You don't have to have that, but some would traditionally have that, and that's where trustees are appointed from. So trustees, they're acting in a personal capacity. So what that means is that, of course, you can resign. Once you sign up, you're not there forever, praise be. But you can't abandon your duties while you're a trustee. And what that means is, if the water's getting a bit hot, if you resign, then you can't just abandon your legal duties. You're still kind of bound for decisions that you make while you're there. Obviously, once you leave, you're no longer tied to the organisation, and any decisions they make, whether they're good or bad, are nothing to do with you. But if you make a decision, or in collective decision making, make that with the rest of your board, it doesn't end up being the correct decision, and something comes as a result of that. Just because you resign doesn't mean that you wouldn't be responsible for that decision, and that doesn't mean that you're suddenly going to be up in court or something like that. It's nothing as dramatic as that. It just means that trustees have to be aware of what they are collectively and individually making decisions about, and they've got to be responsible for those decisions, because that is the whole point of it. You're doing things for the best interests of the charity, and you need to keep that in mind at all times. So I've got a chat box coming up. Well, it's not about Colin, thanks for that question. It's not about the duration as such. It's just if something was, a decision was made that, I'll give you an example. I had it wasn't a charity, but it was an organisation, and some trustees, some directors made a decision, a financial decision, and another director did something without authority from the other directors, and it ended up causing a bit of problems, and it looked like there was a fraudulent thing going on. So although what happened was the directors jumped ship, and they thought if they jumped ship, they wouldn't be responsible for any of that. But of course they were, because some of those financial decisions were made while they were a director. So it's not a case of this duration. It is while you're in tenure, while you're on this board, you are responsible for the decisions that you make, which is why you try and make them in good faith, and to the best of your ability, taking advice when needed. And this is obviously jumping ahead in what we're actually going to talk about, Colin. So, but that's what it's all about. And in the, for the most part, you won't ever be responsible financially or otherwise for any decisions that you make. But it's just these duties are there, they're set out in stone, so you have to abide by them. So I know I didn't really answer your question, because there isn't really an answer to it, I'm afraid, Colin. It is just about, having that responsibility while you are, in office and making those decisions. So, it could, I guess a decision, if it came up 10 years later and you were on the board, I don't think there's an actual duration for that. It would just be any decisions made. But, it's rare that these things happen, to be honest. But the whole reason of duties and responsibilities, it's a carrot and stick. So you abide by them and act in good faith, and it's very unlikely that anything would come as a result of that. But it's your job as a trustee to question things and not just accept what someone's doing. Push back a little bit if you don't get why a certain thing has been proposed to you. So you might not be an expert in everything, so you might not be an expert in finance the way the treasurer is, but it doesn't mean that you can't ask prudent questions about why things are happening. So it's your sole responsibility, but it's your collective responsibility as well. So it's okay to have discussions amongst yourself, and to kind of question what has been done and if it's in the best interest of the charity, because that's at the core of all of this. And you'll hear me talking about it a lot during this session. And it is just about ensuring that you act in that good faith at all times. So just moving on with this, you can delegate your tasks, obviously, but you don't delegate your duties as such. So you can delegate to, staff members or management, depending on the type of charity that you have, but you don't actually delegate their duties. So just because you delegate something doesn't mean you no longer have any responsibility for it. So just ensuring that any delegation is properly supervised, and there's that chain of accountability, I guess, because the accountability does rest with the trustees. So supervising and ensuring that accountability is there is very important. Right, so who can't be a charity trustee? So there is a nice neat list on the charity trustee forms now. So you kind of have a tick box when you fill one in as to who can be a charity and who can't. So if there's unspent convictions for dishonesty or something like that, then you're obviously barred from being a trustee. If you're undischarged bankrupt, as well. But the kind of newer one that we've seen in the last few years is a protected trustee. So that is a debt management instrument. So when you have a level of debt and you're unable to pay that back, you can enter into a protected trust deed, which means that you get a trustee I know a trustee, which is very confusing, that kind of helps you manage and you pay installments and helps you manage your debt and pay it down to a certain amount, and some of it gets written off and that kind of thing. So you would have seen them on the TV and things like that, but they're quite commonplace now. But if anyone on your board has a protected trustee, then they can't be a director or be a charity trustee. So it's always worth looking at, although you don't have to sign a trustee declaration form for every single, time you go on a board. You do in the beginning when you set up your charity, but using those forms can be quite useful for later, just because it helps people sign off, and it means that you can gather the information that you need from trustees for your trustee registers. So you're downloading those forms from Oscar and using them commonplace is quite a good idea, because then you can take it on good faith that they're telling you the truth, that they don't have a protected trust deed. And what Oscar usually do and Companies House do as well is when they get the forms through for a new director or a trustee, they will check them against the the Accountancy and Bankruptcy Register or whatever. So you appear on there if you've got any of the bankruptcy or protected trust deed, and they'll be able to flag that up for you. So anyone who has those wouldn't be able to be a trustee. So yes, it can be an awkward question when you're setting up your board, but if you're putting a list in front of them, then it means that you're taking their word for it, if you like. So if you're removed under Scottish or English law from being a charity trustee, and if you're disqualified from being a company director as well. So those are the people that can't become a trustee. So how do you kind of deal with the disqualification side of things? It is the individual responsibility of the prospective trustees not to act as a trustee while they're disqualified, but is in the collective interest of the trustees to ensure that none are. So the trust, Oscar does recommend that you get them to sign a declaration, even if you're not a new organisation, and obviously looking at other forms of checks and kind of, like PVG and all of the things that you might need to do, rehabilitation of offenders, that kind of thing. So if there's vulnerable people, you need to ensure that you're following those restrictions as well. And actually, it is a criminal offence to act as a trustee while you're disqualified, and there are fines and imprisonment for those as a punishment. So acts done by a person acting as a trustee while they're disqualified are not invalid by reason of the disqualification as well. So even if someone wasn't eligible to be a trustee and they became one for whatever reason, decisions that are made are still valid. They're not, declared invalid just because they shouldn't have been there. So important to note. So when we're setting up a charity, you're kind of setting up this relationship of trust. So it's really, and that doesn't matter about your legal structure. There's usually these fundamental, parts of being a charity. So you usually have the committee, board members, charity trustees, whatever you want to call yourselves, and they're the kind of custodians or the stewards of the funds and the assets. And you've got to ensure that they are being used for the assets that, for the purposes that you're being set up to do. Trusters, that would be people who maybe give you money. So that could be donors, could be grant funders, benefactors, that kind of thing. So in the usual sense, a trustee would be in charge of that money and ensuring that it's used appropriately. And then you might have a beneficiary who is who's been, kind of outlined as being the benefit to the charitable activities or services. So that could be your service users or your clients or whoever it is that you're set up to help. So that is, most charities have all three of these, and it is that relationship of trust. And that's who you are trying to kind of honour. So the beneficiary is ensuring that they get the benefit of what you're doing and ensuring that you're using these assets for the charitable purposes and applying them appropriately. And obviously applying to any grant funding, and honouring any kind of obligations that are set out in that regard as well. And same with any donors or benefactors, anybody leaving you money in their will, that kind of thing, ensuring that that is executed appropriately as well. So the trustee duties, they come from a couple of different places. Common law. So common law in Scotland, that's basically what we mean when things are established through case law. So for a lot of the things that we live by in Scotland, it's by legislation, and the rest is common law. So any case law, everything that's kind of come down by judicial precedent, that's what we mean by common law. So it's like the unwritten rules, I guess, that have come from court and that kind of thing. There's also a piece of legislation, which you'll all be familiar with, I'm sure, which is the Charities and Trustee Investment Scotland Act, 2005. And if you're a charitable company, there'll be company law duties as well. So that is something that you have to balance the two if you're a charitable company. I know that we're specifically talking about SKIOs, but it's still useful to know, because you might be in with your other hats on, it might be charitable company. So it's important to note that you have that dual responsibility in that regard. So the common law duties. What we're talking about here is very straightforward, very common sense, but it is about ensuring that you stick to those as well as what the Act says too. So implementing the charity's purpose. That is probably the one that everybody is more familiar with, just because it's the one that everybody talks about so much. So ensuring that you're advancing the purposes. That is the core part of charity law, what your charitable purposes and how you go about advancing them and making sure that they happen. But it's also about controlling the property and assets of the organisation as well, keeping accounts. You've got to ensure that you are keeping adequate record keeping and accounts according to what charity law says. But you also have to devote time to the charity's affairs. There isn't any hard and fast rules of how much time that is. But, you know, if you're finding that life and your job and other things are getting in the way of you executing your duties appropriately, then it might be time to think about if that's still the right thing for you as an individual. Because if you're missing meetings and you're missing out on the opportunity to participate in the decision making, then decisions could be taken that you might not have agreed to, that kind of thing. So it's just ensuring that you're able to, you know, devote enough time to the affairs of the charity. So conflicts of interest, the management of those is really, really important. And a lot of organisations think that they'll never have a conflict of interest, but you'd be surprised how often they come up. And we're going to talk about that in a bit more detail. Observing the general law and taking advice when needed as well. Excuse me. The specific legal duties in the Act are kind of broken down into the specific duties and the general duties as well. So complying with the 2005 Act, these are the specific things that you need to do. So these are more like practical things, I guess, that you'll do to, you know, adhere to what the rules say. So your charity details on the Scottish Charity Register. I don't know if any of you have been on Oscar's website. You can just search for any charity in Scotland and their details come up. So what you'll see their name, they're kind of known by name if they're known as something else, their charity numbers on there. You might have website details, registered office, the accounts will be on there usually as well. It'll talk about what your charitable purposes are. It may name a trustee. Sometimes it does, it wouldn't name them fully, but it might say, you know, J. McDonald or something like that on there. But that's hardly ever, that's usually for if a trustee is the principal address, so they might include, you know, part of a name on there to identify. But they do ask you when you're setting up a charity if your registered office is a trustee address or not. So it's always good to not have a trustee address on there, as you can imagine, because that address will be public record. It won't be automatically recognisable that it is a trustee address, but you know, it is worth thinking about if there's anyone you can use as the registered office or mail service for that. But one of the things that, you know, Oscar asks you to do is just ensure that that register has the up-to-date information. So when you become a charity, you get a login to Oscar Online. So that means that you can jump on and change certain things. So if you change your address, you can just jump on and change it. And any of the kind of pertinent information, you can just change it immediately. There are some updates that you need prior consent for, and we'll talk about that a bit later as well. But OSCR don't actually need to be updated when any of your trustees changes, because they say that they do not keep a register of your trustees, because it's up to you to do that. Under law, you have to keep a register of your trustee board. So it's up to you to ensure that you're keeping your register up to date in that regard. So although OSCR asks you for the initial trustees, they won't be up to date with, you don't, it's not like Companies House where you have to update them every time it changes. You don't have to do that. It's entirely, your responsibility to ensure that you've got an adequate list of who your trustees are, and when they left, and that kind of thing as well. So the trustee register is, it's a requirement by law in company law and in charity law. A register of members as well, but we'll talk about that in a bit more detail in a minute or two. So reporting to OSCR, they need to be advised every year of your with your annual monitoring. So that needs to be done, in a yearly fashion. So you've got a date once you become a charity. It's like your accounting reference date. So your accounts will run from one date to another, a period of 12 months, and you'll have to submit an account and reports to OSCR every year in that regard. So say if your year end is running from 1st of April to the 31st of March, by that following December, you will normally need to submit your accounts to Companies House, if you are one, as well as OSCR. The good thing about OSCR is if you're late, they won't be angry at you. They give you lots of leeway. Obviously, it's never a good idea to be late, but they're usually okay if you are. I have seen certain charities on there and they're years late, which is not good, obviously, but it's not like Companies House where if you're late, you get a fine. OSCR will just give you plenty of time to do it, but just, to keep on top of things, just ensure that you're doing things, in time, and that you're getting your accounts, prepared in adequate time to be submitted when they're due. And OSCR usually sends you a reminder when they're going to be due as well. So the annual accounts will follow its SORP, it's called. That would probably be a whole other session, to be honest, and accounting isn't really my bag, but there's lots of useful guidance on OSCR's website for some of the requirements. So depending on your level of turnover and the type of entity that you are, you will either have to do receipts and payments accounts or fully accrued accounts. So the receipts and payments are a very simplified version, kind of a bit like a cash statement. It is just your ins and outs, and it's fairly straightforward in that regard. They will have to be examined by an independent examiner, but you won't necessarily need a full audit for those. Or you can have the fully accrued accounts, so they're a bit more sophisticated and a bit more in detail. And those, you would need those examined as well and possibly audited depending on your turnover, but speak to an accountant about those kind of particular requirements. But OSCR's website has a lot of styles and templates and things on there, so you can at least see what's in the post for you if like me, accounting isn't your bag, just so you can get a gist of what you're responsible for. Some of the other things that you need to report to OSCR are when you make changes to your charity as well. So financial records and reporting, obviously a part of your accounts. Fundraising, there are certain duties and responsibilities around there. And actually, when I was doing a quick Google search for any additional things I could put in this workshop, there was a whole fundraising workshop workshop about all of the kind of responsibilities around that and what you're allowed to do and what you aren't allowed to do. So if that's something that you're interested in, there is resources out there. And I'm not sure if Engage have any fundraising workshops on the go, but if that's something that you're interested in, there's definitely content out there if you want to do that. And the last thing on the slide is about being accountable to the public. So OSCR are a bit of a real stickler on this, because they feel that charities are, you're public facing, you are and should be accountable to the public. So the way that you do that is providing information to them. So that could be by way of, your accounts on your website, or, showing your governing document on there, that kind of thing. So these aren't things that are necessarily in law, although, providing information to the public is, these are just examples of things that you might want to do to be completely accountable to the public in that way. So just going into a wee bit more detail, excuse me, on the financial record keeping side of things. So the Act states that you have to keep proper accounting records and prepare that statement of account, including a report on its activities by the end of the financial year. So the trustee report is included in that. So that just kind of goes into detail about what kind of things that you've done over the course of the year, you know, notable achievements, how you've advanced your purposes, that kind of thing. So again, it's about ensuring that you're passing the charity test always with the things that you do, you're advancing your purposes, and your trustee report will kind of go into detail about that. Sometimes they're long, sometimes they're not, and you don't need to necessarily include every purpose that you have. It's just, you know, the things over the course of the year and how you've gone about it is in there. So some charities do a real fancy version of it, but you know, that's, you know, it can come in whatever form you want it to, as long as it shows that it's the trustee report, and that goes along with your accounts and accounting records, and that's submitted to OSCR. So when you submit it to OSCR, you can do it also through the OSCR online portal. So you could just go through the steps and put in, there's text boxes, and you just, you know, put the figures in as well for that, and then you can submit the whole thing at the end by PDF, I believe, and that, you know, that will show them, and usually it'll go through their relevant department and they'll give you a nod that it's been acceptable to them, or if they've got any questions, it'll pop up a bit later, any queries that they have in that regard. So having your account independently examined and or audited, depending on your level of turnover, and sending a copy of the accounts along with a return to OSCR, as I've just said. So because of the retention of records thing, you do need to keep your accounting records for 6 years following the end of the financial year that you were made. So 6 years is, some people choose 7, but 6 years is all that you need to do in that regard. And you don't need to keep paper copies, by the way. You know, electronic is fine, obviously. So providing information to the public. So you having your charity name. So if that's your official name, if you're known as something else, that's fine, but you definitely have to have your official name on there, and your charity number, and obviously state that you're a charity as well. So that could be on your website, on any invoicing paper, any kind of letterhead, however you go about it. So adverts, posters, you know, leaflets, you know, anything really that's going out in an official charity capacity, you need to include your name and number on there and state that you're a, you know, a SKU if you're a SKU. So the copy of your governing document or accounts, the whole accountability thing, if someone asks you for those things, there shouldn't really be any reason why you withhold them. So it's very rare, again, that someone asks for it, but sometimes you might get the odd person who's very interested in what you're doing. I wouldn't say troublemaker, because this is an official recording, but sometimes there is people who are, you know, want to cause a wee bit of a stushy within the organisation, or they're not happy that they weren't involved or part of the board or whatever. So, you know, sometimes someone might try and cause you a bit of bother, you know, and using, sometimes they'll throw freedom of information at you, sometimes they'll throw GDPR at you to try and get things out of you, and that's obviously fine. You have to honour your responsibilities under the law for those things. But when it comes to your governing document and accounts, really there shouldn't be any reason why you don't give them out if someone asks for it. And obviously keeping in mind the GDPR aspects, you can redact whatever information you feel is appropriate. But nowadays, OSCR put the accounts online anyway, and they redact information. So, you know, even pointing them to that, or, you know, putting the same copy on your own website would stop any admin issues with having to kind of deal with any requests like that. But just having them there can be a good idea about that whole accountability thing. And it's just a good idea to be totally upfront about those kind of things. And your governing document, if you're a SKIO, you wouldn't have your governing document isn't exhibited in anywhere, because OSCR don't do that yet anyway. Companies House, the articles are online for anybody to pick up if they want. But OSCR, they don't do that. So if anybody wanted to see it, then, you know, there shouldn't be any reason why you wouldn't let them have them if they asked for it. But again, you know, that hardly ever happens, but sometimes it does. So general duties. It's about acting in the best interest of the charity and putting the interests of the charity before any other, including, you know, your personal interests. You've got to ensure that you're acting in a manner that's consistent with your purposes, and acting with due care and diligence, and ensuring that you adhere to the Act and any relevant legislation that's in place from time to time. So those are the things. It's quite, they're quite straightforward. Most people would act in that way as a general rule anyway, but this is just to concrete, to underpin everything that you're doing, and acting in the best interest of the charity is numero uno when we're talking about that. So you put the interest of the charity before your own, or any other person or organisation. So if you're on multiple boards, it's about looking at the organisation that you're representing at any one time and ensuring that no other organisation is clouding that judgment, and that includes the interest of the person or body responsible for the appointment of trustee. So that is just going back to the initial slide that I put about sometimes you might have a trustee appointed from a particular body. So even if you are there appointed by that body to kind of represent them, you have to kind of balance it with making decisions that are right for the charity while you're there as a trustee. You can obviously do both at the same time, but it is important to ensure that you're making decisions that are in the best interest of the charity, the advancement of the purposes, and ensuring that those activities are doing that, and ensuring that the decision making around it is appropriate and relevant, and advancing that as well. So again, these are really common sense things. It's not difficult to do that, and when you are kind of in the stride of being a trustee, you won't kind of think about these things, really. But your governance. Good governance is, it's one of those things that you put in place, you live by it, and then it just becomes like custom and practice. So you don't really think about it anymore. But it is just about asking the right questions, ensuring that you are sticking to what your governing document says, that you're following that document, that you're ensuring that, it's not just about ensuring the survival of your charity, although decision making will sometimes feel that way. But really what you're talking about is ensuring that what's the best outcome for this charity based on this decision. What can we do to ensure that we're furthering our purposes, that the beneficiaries are getting what they need from us, and that kind of thing. So part of the whole duty thing is managing conflict of interest, because you can't always avoid them. It's about the management of them and mitigating the risk attached to that. So when the interests of a charity conflict with the personal interest of a trustee, or the interests of another person who appointed a trustee, or anyone kind of connected within it, if there's someone in your membership who view the trustee as their representative, conflicts can sometimes arise. But again, the kind of multiple board thing, sometimes the interests can be conflicted in that way as well. So it's about declaring them, being as upfront, open and transparent as you can. So if you kind of get a sniff that someone's got a conflict, or you think that you've got a possible conflict in the future, it's about declaring those potential conflicts as soon as possible. And the best kind of practice around it is withdrawing from the discussions on those particular matters that's bringing up that conflict as well. And, ensuring that, another bit of good practice is that you record these as well. So have a kind of register of interests. So if you're seeing patterns in certain behaviours and a lot of conflicts coming up, then you might want to deal with that. So having a policy or a code of conduct can be a good way of dealing with them. Governing document usually will go into a little bit of detail about how to manage conflicts, and it'll be kind of quite near the end, but around about the trustee section, you might have a little bit in there about that, which can be your kind of first point of contact, I guess, and then you can refer to your policy and make sure that they complement each other, or your code of conduct as well, just to ensure that you have the process set out and that there's no confusion about what you need to do in the event of a conflict. So again, it's not about avoiding them, it's just about managing them appropriately. So it could be that a conflict of interest, although someone's declared one, it might not be something that the charity board are too worried about. So sometimes you can authorise the conflict if you still want them to partake in the discussions, but the safest way is for that person to be removed from the Zoom call, or in the old days when we used to have face-to-face meetings, they might want to step out of the room for those as well. And if you do have a repeat offender and someone continually breaches and keeps propping up as a you know, having conflicts left, right, or centre, you might be thinking, are they acting in the best interest of the charity? Because that keeps coming up. So there are provisions in law to remove a trustee in really serious, you know, or persistent breaches of the thing. So you can remove a trustee. And it's a last resort though. So, you know, it's not great, it's not ideal, but it's there if you need it. But it shouldn't be used just to get rid of people that you don't like, you know, but you know, it's there because you always need an out if things get really particularly bad in that regard. And it does sometimes. I think I probably see the worst because people come to me after these things are, you know, past the point of no return. But, you know, it is important to kind of note these things and to get your kind of paperwork in order when you're getting going, and just making sure that you're dealing with these and you know what to do if something were to happen. But Oscar's website has some really good guidance on it. And there's lots of governance codes and things like that that you can, you know, refer to for those. I'll give you, you know, a link or two at the end of the slideshow. So the onus is on individual trustees to declare these potential conflicts, but the board should really be encouraging that culture of transparency and good faith in that regard, so that people can feel open and be able to share those potential conflicts, because it's not a bad thing, it's just the management of them that could be done badly. But sometimes you might have, you know, something that is in the best interest of the charity, but at the same time it might be connected with you in some way, but it doesn't mean that it's bad for the charity. But, you know, the trustee board would make that decision as and when that happened. So acting in a manner consistent with the purposes. So trustees have to ensure that that all of your activities further the purposes as stated in your governing document, and that all provisions of your governing document are complied with. So I get to see, most of my work is governance. So I see a lot of governing documents, a lot, more than you would probably ever like in a lifetime. And I see the good, the bad, and the ugly with them. And I see a lot of people who don't actually refer to their governing document ever. It's, you know, yeah, it's not great, but, you know, it's about taking steps to ensure that that doesn't continue to happen, because I know certainly when we recruit new board members, you know, they get an induction pack with the current constitution and all of those kind of things, so that they can join the board seamlessly and know exactly what they're getting into, and you know, financial projections and all of that kind of thing, so that they can, you know, join or not if they don't want to. But the governing document, that's your, you know, that is one of the key documents that you hold within your organization. So it's definitely important that you know what's in it, and that it's, you know, always up to date. And it doesn't mean that you need to change it every year or even every 2 years, but, you know, keeping it in mind that, you know, if activities change or you have an idea for other activities that you may want to do, refer to your governing document, because it gives you all the information that you need. You know, it goes into detail about what your purposes are, what your powers are. It'll tell you how to run your meetings or your members' meetings with your trustee meetings, your quorum set for that. It, you know, some, you know, governing documents have bylaws attached to them. So it's really, really important that it's an active, breathing document, really, and it's always referred to in most situations when you're doing things, so that you can ensure that you're furthering the purposes, you know what they are. As well, because it's amazing when if there's, you know, trustees leaving, that, you know, it can get lost in translation sometimes. So keep an eye on that can be a really, really good idea, and ensuring that you just know what's in it. It's not like you have to have it memorized, but enough to know when it might need to be changed or updated as you go. So the other part of that is ensuring that your assets are not misapplied for non-charitable purposes or any other purposes that are stated in the governing document. So hugely important, you know, it's a part of the duty, part of the law surrounding your charity. So making sure that all your trustees are familiar with that. So like I said, a good suggestion is to get a copy of that when they join the board, and that you can work together to make any changes as and when you need to. And that trustees receive regular reports on the activities. So depending on what type of structure you have, you might have a board that is fairly active because they are the people who are running things day to day. But obviously you might appoint staff to do that. So it could be a CEO type role, managing director, whatever the kind of key personnel is. So knowing what's happening on the ground. I mean, obviously it's not, the trustee's job isn't necessarily about, you know, the day-to-day operations. If you have appointed staff to do that, but you know, it's just that general overview so that they can make strategic and financial decisions, and ensuring that you're fully involved in those planning decisions and applications for funding, that kind of thing. But again, these can be delegated, so it's really important to notice just because you're trustees doesn't mean you're going to have to be filling in big lottery funding applications. You know, you can have staff that do that for you, but as long as you have that kind of overview of it, so you know what's going in and what's being done and that kind of thing. But you know, the trustees getting a kind of full induction into the charity and the work when they're appointed can be a good starting off point. And I have templates if anybody's looking for anything like that. Acting with care and diligence. What we mean by that is that what is reasonable. So that's a thing, that's a word that we use in law a lot. It's about this reasonableness. And when we're talking about charity trustees, it's that care and diligence that is reasonable to expect of a person who is managing the affairs of another person. So it's consistent with that idea of being a steward or a custodian of the affairs of another person. So it has to go one step further than if you were even dealing with your own affairs. So you've got to have that care, that due diligence, and making sure that you are you know, having an overview of that, and that you're kind of managing in an appropriate way. So this care, skill, and try again, Karina. Care, skill, and diligence, a duty of company directors. So the benchmark there is a step down. So it's as if they're managing their own affairs. I hate how it says his always, but that's what it does. But anyway, you know, they managing their own affairs. So it's that idea that in charity law, you've got to go a step further than that. So as if you were dealing with the affairs of another person rather than just your own. So with extra care and extra diligence is what we're talking about here, and putting the affairs first. So what does that mean? Really, it's ensuring that your charity is run properly, responsibly and lawfully, ensuring that your charity is and remains solvent. You act as the guardians of the charity's assets, and ensuring that your board is fit for purpose as well, and that you've got the appropriate people on there, and that the trustees are working well together. And if there are areas of conflict, and I don't mean conflict of interest, I mean actual conflict between the trustees, then ensuring that you're dealing with those as soon as you can as well. It's okay to have healthy discussions, but you know, if conduct is slipping a little bit, then you know it's time to address some of those. And again, maybe this sounds like, well, you know, my board wouldn't be like that, and that's great if it isn't, but you know, there's been some board meetings I've been in, and yeah, it's not been great. So I hope you can hear me okay. My computer's telling me my internet is a bit iffy, so good. So, and you're applying that duty of care to your paid staff and your volunteers as well, and that you exercise reasonable business sense when you're concluding any contracts on behalf of the charity. So we've got a chat popping up. Thanks, Colin. Yeah, my internet just told me I had a really unstable connection, so hopefully I'm back now. I don't think I was saying anything particularly interesting anyway. But yeah, the care and diligence side of things, you know, these are common sense. And, you know, I think probably anyone looking at this list, it doesn't look that scary, and it's just about ensuring that you put that charity first, and that you're making reasonable decisions based on the reasonable nature that anybody would when they're dealing with those affairs, and making sure that the charity kind of keeps itself ticking over, and that you remain in that solvent position as well. So there's no kind of qualification that you need, or any specific skills, experience, ability, anything like that. It's not like Stepford Trustees where they just come out popped out perfect. You kind of learn it as you go, and sometimes you might make some mistakes along the way, but it's about rectifying them and just doing what you can. And if things are done as reasonably as you possibly can, so if you make a decision that maybe wasn't great, it's, you know, you made it in good faith, you took advice, you know, you did everything that you could, then no one's going to penalize you for that. You know, the law kind of recognizes, and it's recognized that especially, you know, charity trustees, a lot of people they won't necessarily be coming from a commercial background or a professional background in some situations, but it's people who act in the best interest in good faith, and that's all that the law expects of you, really. But it's that sound judgment, and kind of looking at risk, looking, doing things in a cautious manner, just as any reasonable person would, as you're going along. So, it's not an overly high standard to meet. It is just about looking at these things in a sensible, the sensible approach, and what's the best way that we can make this decision, and taking it from there. So it's not, it's not overly onerous. It just, I think when it's written out in a certain way, it can look a bit daunting. But no one, you're allowed to make mistakes. Then no one expects you to be perfect doing it. And what Oscar is really, really good at as well is you can approach them about anything, and they will give you a solution, because the last thing that Oscar want is for any charities to be removed or to wind up. They don't, they want as many charities as they possibly can on there, and they don't want anyone to have to leave for any reason. So even if something pretty catastrophic has happened, it is a good idea to approach them, because they're fantastic. And even if, because they're a public body, there are channels for people to complain about charities. So there's an area on their website that anyone can put in a complaint, whether it's founded, unfounded, or just general lies on some occasions. But Oscar and, they have to honour any complaint that comes in, and they have to investigate. So even if you get a surprise letter from them one day saying, we've got some concerns about how you're running your charity, which some of my charities have, and usually is, an aggrieved person in a community, or, an ex-trustee or something like that. But again, I see the worst, don't forget that. And more often than not, even there was one case that was, there was some pretty serious financial mismanagement, and they gave them opportunity to change it, and they wanted to change it, and they got it back on track. So there's lots of opportunities to fix what might be broken within your charity, because no one wants it to close. Nobody wants that. So Oscar are great in that regard. And if there's anything, and a lot of the time they just refer you to their guidance, which is fine and great. So the guidance is always a good start to look at first. But if you're still unsure, Oscar themselves, or an advisor like myself, can help you with it. But that in itself is you acting in good faith, is kind of taking steps rather than not being an ostrich about it, and kind of trying to avoid it completely. So lots of there's lots of opportunity to fix any mistakes that might have happened along the way. So it's just a wee note to, Oscar aren't a big bad regulator or anything like that. They're actually very approachable and can give you the advice that you need. There's lots of other advice out there as well, as you know. So duty of legal compliance. So you're expected to kind of comply with any direction, requirement, notice, duty, by any kind of law that might be applicable to you. So other legislation that you might want to think about, company law, if you're a limited company, or maybe if you have a subsidiary that is a limited company. Employment law, so that's an ever-changing beast, that one. Even advisors don't even know what's going on half the time, because there's so much changes. But it is one of those things that you need to kind of keep on top of as much as you can. Health and safety. So again, the standard of reasonableness comes into health and safety as well. And risk assessments and all of the things. There's loads of really good content out there on health and safety. The Health and Safety Executive has loads of risk assessment templates and all sorts of policies and procedures that you can use depending on your area of business. So if you're in the world of caring, then obviously you need to be registered with the Care Inspectorate and adhere to their requirements. Data protection, everybody's favourite. So if anybody needs any GDPR stuff, you can let me know about that. I've got lots of templates that I created when GDPR hit, if anybody wants them. So if you're licensing or any kind of entertainment things that you might need, lotteries, that kind of thing, then there's specific legislation about that. Equalities as well, tax, property, insurance. That's obviously, the list isn't exhaustive, but it's just a flavour of the things that might affect you. PVG as well would be one of them. So this collective responsibility that I've kind of mentioned a couple of times, that is, you're thinking of yourselves as a board, as a unit. So you are making decisions collectively, You share the duty, you share the responsibility, but you're equally accountable for the decisions. So you are individually responsible as well. So it's just one of the things that how you make decisions. So I mentioned earlier about you not attending meetings if you're not able to, and that continually happens. You're not able to participate and make your decisions. So it's about thinking, is that, is this the board for me? Am I giving it all that I can? That kind of thing. So you don't want this collective responsibility to bite you in the bum later when decisions are made without you participating in them. So there's some function that may be delegated to staff, subcommittees, etc., but the responsibility itself cannot. So obviously you can use subcommittees, which are a great governance tool to make decisions, or if they're staff, but the overall responsibility lies with the board. So even if mistakes are made by staff members, it would be the trustee board that would be kind of responsible, have the responsibility for that if anything were to arise. So trustees should not be making any minority action except where it's expressly, authorised by the trustees in the governing document or any other kind of scheme of delegation or something similar. So sometimes we'll get inquiries about a trustee who's just gone off and done something without the authority of the others. So again, that's more of an internal issue to be dealt with, because there shouldn't be anyone who feels that they're able to do that without express authority, and those decisions should be taken collectively. So it's quite an important one. So if you do have a sole trustee who has been authorised to do that, they're doing it for or on behalf of the charity, and that they have to make sure that they've been given that authority to be able to do that. So that record keeping is really important to ensure that all of these actions are authorised. So your minutes, that's where your minutes come in. So your minutes that maybe outline a decision that's been made in a certain way, but also you might have a scheme of delegation. So you might have that, set out. So say if you've got like a CEO type role, you might have the delegated authority that they have. That could be financial decisions or otherwise set out. So there's really useful templates out there, if that's something that you're interested in, just to make sure, because it's not about having loads of paperwork, but it's about showing how you plan to do things. So sometimes policies, procedures are just how you do that. It's very difficult to keep it informal, not that you would want to, but ensuring that you have something to show what your decisions are in that regard. So that's why some of these templates and you can be really useful, because some boards find it really useful to have a subcommittee. So it could be an HR or a fundraising committee or whatever you want. So it's a smaller group of people, not always made up of trustee board members either. It can be made up of lay people, as long as there's a trustee there that is kind of overseeing it, would be a good idea. Okay, so thanks, Jules. Jules is asking how we might keep records of decisions made via email, smallish ones, but still important to show a trail of yes, this was authorised and unanimously agreed on. So you might want to do a kind of minute, so a minute that kind of records that, because it wouldn't, to keep every email that's done in that way could be, it could be quite challenging to do that. So you might want to just put together a little minute to show that that was agreed on that date, and do it like that. So nothing fancy, just, just something that via email, the board agreed to ABC and the date that it was agreed, that kind of thing would be sufficient for that way. Because any decision that's made, if you have a meeting virtually or otherwise, minutes are taken, and you type them up or whatever, and store them in whatever way. But if you're doing those effective, I've seen trustees make decisions by WhatsApp, and that's okay. You whatever is effective for you, do it, as long as it's recorded in a more official capacity, I guess, so that it'd be very difficult to like print off your WhatsApp feed, and there might be bump on there that you wouldn't necessarily want to have to keep. But if you just record the decision, that would be sufficient, to show that decision was made in that certain way. So again, there's no hard and fast template for that. There's no hard and fast rules on it. It's just record the decision any way you say. So if it is email or WhatsApp or text, or even just a phone call. So as long as people have the opportunity to participate at board level, just record that decision in any way you see fit. So as long as it's recorded and kind of electronically stored or whatever, that will be more than fine for it. because I referred to the, like if Oscar had concerns about the way that you would run your charity, some of the things that they ask for might be minutes of decisions taken. There could be, you know, something like that they would want to demonstrate that you've shown that proper decision making. So, you know, I've had groups who didn't even have minutes, and we had to kind of reconstitute them, which is not a great idea. And you know, Oscar can pick up on that. And you know, there was one case in particular that you know, was a complaint that someone put in, and I helped them kind of navigate their way through it. And you know, they didn't take proper decisions because they did it by WhatsApp, they did it by email, but they weren't recording them. So we had to kind of reconstitute the minutes, which isn't, you know, isn't a good idea because they should be recorded in some way. But you know, for Oscar's purposes, they were fine with that. We were upfront that that's what was happening, and we noted to them at the time that yes, there are some governance concerns here, but this is what we're doing to fix that. And they were happy with that, and the complaint was unfounded, and nothing happened as a result. But Oscar's kind of direction was make sure you take adequate decisions, record them. Here's a style, that kind of thing. So they were really, really useful in pinpointing that. And just, you know, for the board themselves, they recognised that they were letting standards slip and they weren't necessarily doing things in the best way that they could. So they corrected them, and I believe they're fine now. And they're recording their decisions, you know, in the best way that they can. So yeah, these things are just as important. The record keeping is important too, for doing it. So breaches of duty. So you've got a duty to correct those duties. Right, I've got another question. Give me a sec. Yes, yes. So that's Jules just coming back to say, you know, that electronic ways of making decisions are more commonplace for the board. So definitely, you know, use those because it's about effective decision making. So it doesn't mean you need to be, you know, at a board meeting to do those because that's just not as effective, especially with things how they've been in the pandemic. You know, people are virtual, and you know, you're not seeing people as much as you were. So whatever way you need to make your decisions, go ahead and do it. Just record them appropriately so that, you know, anyone can see what the decision making was and what was decided, and that kind of thing. So it's like, you know, another thing that people tend to do as well is with their minutes, it's like War and Peace. It's like you don't need that either. Just, you know, as long as it shows the discussion and summary and what decision was made. My old line manager, his rule for a lot of things is don't let it go over an A4. If it goes over an A4, then it's not good, it's too long. But obviously that's, you know, it was a bit of a joke that we had, that nothing was ever allowed to be longer than an A4. So that's not a rule that you should maybe use in your own organizations, but certainly, you know, summarizing, but just, you know, recording the key points, that's what's important here. So the duty to correct breaches of duty. So again, it's this reasonableness. So the board should really look at taking the step to ensure that any breach of a duty is corrected. So you give people a chance to rectify behaviours and ensure that it isn't repeated as well. So that serious, persistent breach of duty, get them gone. There's just, you know, there's no room here to be kind of nice and let people just be on there if they're not doing their job. So you've got to be quite bold about it in a way, because sometimes you'll see and you'll know in your gut that they're not, you know, they keep breaching their duty, they're not doing what they're supposed to, they're not following the collective responsibility of the board, so they need to get gone. So there are legal provisions to do that. Usually it's a meeting by special notice, and the right to be heard is usually there as well, which can, you know, you can imagine how awkward and horrible that would be. But it is a good idea to use those provisions if you have to. But like I said, you don't use it just to remove someone that you don't like or someone who's kind of awkward. It's about breach of duty and only taking those steps when you need to. But that's, you know, you might have a code of conduct that you might want to set up, and if someone's in breach of that code of conduct, then, you know, there's remedy behind it. It's in the same way as, you know, when you've got staff members, you've got grievances, you've got disciplinary. I'm not suggesting that you apply those same things, but, you know, the standard that you set is entirely yours to set, and it is a higher standard. So if people don't meet that, be prepared to deal with it as and when, because, you know, it's not about, it's about the duty to ensure that the charity meets its purpose. So the kind of things that you need to think about when you to comply. So record keeping, a register of members. So if you have a small membership where you're, or a single tier, where your members are your trustees, you only need one register, because it doesn't, wouldn't make any sense to have two that have the same people on it. But if you have a two-tier, where you have a separate body of members, then you need to keep a register of both. So usually within the SCIO constitution or your articles of association, it will say what you need to keep, but it's usually for members, name, address when they became a member, or when they left, because you need to keep that for 6 years. Register of trustees, similar, a similar thing, a similar kind of style of, name, address, date of birth, previous trustees maybe, but they're not always required by law, but certainly useful to keep. So that's why using the trustee declaration form from OSCR can be useful, because it captures all of that. But again, you need to keep those details for 6 years. For financial record keeping and for record keeping in general, but also within the SCIO, there's a specific rule that if anybody tells you of any changes to their address or whatever, you need to update those registers within 28 days. So it's just a thing to know, because we were talking about SCIOs last week, and I know I mentioned it then, but. So financial records, as well, your minutes of your board meetings and general meetings as you go as well. So your submissions to OSCR, trustee report, annual accounts, any resolutions passed which change your constitution. So if you're changing your purposes, it's a different process, because you need consent first. So say if you want to change your constitution and you don't want to change anything to do with your charitable purpose, you can just go ahead and do that. So it's a member's decision. So depending on whether you're two-tier or single-tier, you will hold a meeting to do that. If you've got a larger membership, you usually would need to hold a meeting. But if you've got a smaller membership, it can be done by written resolution. You adopt the new set of the constitution. You advise Companies House if you're a company, and OSCR after the event. So if you're a limited company, you've got to let Companies House know within 15 days. OSCR don't need to be notified until within the 3-month period after that's passed. They will accept it, it's fine. If you are changing your purposes, you need to ask OSCR first. So you put in an application to ask for their consent. You put in what your new purposes would be. So you send in a draft new constitution with your new purposes within it, and they will consent. You've got to give them 6 weeks notice as well. So 42 days is the kind of key bit that they need. They sometimes come back within that time. So, if you're looking to change your purposes for funding or something, get it done sooner rather than later, because you don't want to be at war with deadlines in that regard. So OSCR will say yay or nay, usually yay, if you've given them all the information that they need and that you pass the charity test with those changes. They'll give you consent, then you can move to change your constitution in the same way. And you still need to notify them after the event in the same way with their notification form, which again needs to be sent in within 3 months of the change passing. And they'll acknowledge it by email and say that the register has been updated in that way. So it's just getting the steps right, but it is easy, she says, to change your constitution. It's just about getting those steps in order. So if you want to change your legal form or reorganize your charity, again, these are consent processes. So when you're changing your legal form, it could be, if you're a SCIO, there's nowhere else to go. So you don't need to, there's no point in even thinking about that. So Jill, you're asking, do we need to notify OSCR about changes to membership details? So if you mean changes to the members, absolutely not, no, because that's why you keep your register of members. It's so that you keep up to date. They don't need to know. When you register as a charity, they'll want to know who your first 2 members are. If you've got more than that, you'll tell them more. But any changes to any membership is your responsibility as a trustee, and they don't need to know about that. So that is not one of the things that they need to be advised on. Same as trustees. They don't need to be advised on that. So just going back to changing your legal form. Sorry, there's another chat. The type of members. Well, if you're changing your type of members, Jill, then yeah, because it would be a change to the constitution, because your membership categories are outlined in your constitution. So although you wouldn't necessarily, you notify them as part of the process of changing your constitution. So within the notifications form, if you're changing your membership categories and anything to do with your membership criteria, That would be done by a special resolution by your members. So therefore, in your notification form for OSCAR, there is details on what you've changed. So it'll ask for, if you've changed certain sections, even the number of, what numbered clauses have changed, or if you're just doing a general refresh, then you'll tell them that. So if it's a type of members, yes, you do need to notify them, but it's not just about that. It's more part and parcel of the bigger kind of change to the constitution. So yes, but it needs to be done in that certain way because you're adopting a new constitution to do that. So you need to advise them accordingly of that. Again, it's within that 3-month period that you need to do that. And that's important to get that submitted. But usually it's a good idea once you pass your resolution that you just do your notification straight away, because then, although they give you 3 months, it's easy to forget in that time. So just to do it straight away so that they know what your up-to-date constitution is, and so that you know that you've met your duty to do that as well. So going back to changing the legal form, if you're changing from an unincorporated charity to a SCIO, or a charitable company to a SCIO, a charitable mutual to a SCIO, it's a consent process, and you need to go through the process to do that with OSCAR, ask for their consent. If you have a charity, an existing charity, and the governing document doesn't allow a certain thing, or it doesn't have the power to do a certain thing, or it doesn't allow you to transfer your assets, or it doesn't allow you to dissolve, or whatever. These are just experiences that I've had recently. Charity law allows you to reorganize your charity, it's a really long and drawn out process, but it's really, really useful for maybe some older constitutions that haven't been drafted properly. So it allows you to reorganize, and they give you consent to do that, and then you go ahead and make the change. But these are consent processes. So if there's anything like that, you need to ensure that you're asking for their consent first. Change of name is another thing. So if you want to rebrand and kind of change the name of it, then you have to ask for their consent to do that. And then you go through the change of name process in the usual way, and update your paperwork and kind of go through it like that. There's a similar process in Companies House as well. So wind up, if you want to dissolve your charity for whatever reason, solvent, insolvent, or otherwise, again, it's a consent process, and there's set forms and set processes all on OSCAR's website for these. So really, really useful to take a wee surf around OSCAR's website to see all the different things. So a couple of the other things that you need to do is, if you want to change your principal contact, when you set up a charity, you name who the person is that you would want contacted by OSCAR for anything. Usually it's by email. Sometimes they send the odd letter out. So they need to know where to send that and who to. One of the board is fine, a chair, treasurer, whoever, secretary, whoever. But usually they would need a trustee for that. But again, you don't need a consent to do that. You just go pop onto OSCAR Online and do that. Same with the office address as well. So these are just things to kind of be aware of as you're going. So risk. Management of risk. The reasonableness comes into this. And although this slide looks kind of scary, it's not meant to, and it's nothing to be afraid of. The fact is, you are acting as a custodian, you're acting in the interest of the charity, you've got legal duties. So therefore, if there's a legal duty, that means that there's a punishment if you don't follow that duty. So the risk is attached to it. Usually there's no risk attached to being a trustee. You have limited liability, usually with the structures that you choose, especially the SCIO or the charitable company, or the company alone. If you're unincorporated, then you do have financial liability, because you don't have a legal entity. Because charity law in itself doesn't give you limited liability, it's your structure that does, or doesn't, as the case may be. But the way the legal duties are set out, there's a potential for liability there. So if you're in breach of a duty, it's not been rectified, and OSCAR feel that you're being in breach of duty, there can be consequences of that. So you could be, struck off from acting as a trustee. You could be fined up to £5,000, or actually go to jail for 6 months. Again, this never happens. Can I just point out, it never ever happens. But they have to tell you what the penalties are for that. So when you're looking at financial liability to do with your structure, if you're unincorporated or at a charitable trust, you don't have any protection from financial liability. And that extends further than your kind of legal duties, because the entity in itself doesn't protect you. That's why we look at SCIOs. That's why we look at limited companies, because they do offer you the protection from financial liability. from that. But it's a bigger picture than that, because the way that you protect yourself as a trustee is through your structure, through good governance, acting in line with your duty. Did I say insurance? Yeah, didn't I? Insurance. I'll say it again, just to hit it home. It's all part and parcel of the protection of the board, so that you can ensure that you are protecting yourselves and each other from any liability. And just because these risks are there, it doesn't mean that you shouldn't become a charity trustee. It just means that you just need to be aware of it, that it isn't just something that you go into willy-nilly. It isn't just something that you put your name to because it'll look good in your CV. It's because you want to be dedicated to the running of that charity and be part of its strategic financial control. That's what it's about, and ensuring that you meet the purposes as they are set out as well. So all of it, if you see from the duties I've just gone into, they're not hard. So usually accidental breaches are something entirely different from intended, if you're doing something intentionally, or reckless, intentionally reckless as well. So it's just about keeping that in mind. So there are consequences where duty, where there's a duty, there's a consequence to the breach of that duty. But again, it's nothing to be worried about, but just ensuring that you meet your duties, act in good faith. Even if you make a mistake, you haven't done it intentionally, you've done all that you can to make that decision appropriately. So therefore, there will never be any liability coming from your role. So insurance, that's one of the things that we need to think about as a board. So thinking about indemnity insurance. So public liability, obviously everyone's familiar with that. Trustee indemnity, again, it's not a legal requirement, but can be useful because it protects the trustee and their decisions, not the charity. It covers legal expenses, civil awards, court action, that kind of thing. So it doesn't protect you if you acted out with your powers negligently or broke the law. So again, always look at the exclusions and what it covers if you're going to take it. But again, it's that the only reason that any of us have insurance is about comfort, is so you have that level of comfort that you're covered for things. But making sure you read your policies is a good idea. Public liability protects the charity, making sure that you are reviewing it that it covers everything that you're doing, and keeping records of who your insurers are as claims can arise years later. So, the weird thing about insurance is that there's not actually any of them that are a legal requirement apart from employer's liability. That's the only one that's actually a legal requirement. The rest of them are just good practice, and you should definitely have them so that it protects everybody. And there's some funders or some, people that you deal with that would ask for you to have public liability insurance just so they can ensure that they are comfortable with you dealing with you and that kind of thing. So just a wee side note, again, it's not about your responsibility, but just a wee side note about insurance because, why not? So decisions, when you're making them, I just put together this little checklist just, for fun. So thinking about the decisions that you're making, does it match the purposes? Is it consistent with it? Are there any other considerations that you might want to do? Do you think about even? Any other regulators, legislation that you need to keep in mind? Does it fit with your strategy, your agreed thing that you're planning on doing? How about the financial implications of that? Does it impact on the budget? Is that a necessary risk? Is it a financial risk you want to take? Do you have the skills to implement or police the decision? What's the public benefit with that? Because that's a consideration under charity law. Is there any private benefit? Is that a conflict of interest that's arising with that? Is that something that you can manage and mitigate the risk attached to that? So that's what we're talking about here. It's just being mindful of those and ensuring that, the charitable purposes are always being advanced in that. So I've thrown these in because I know we've it's all about the scale in these 3 workshops, but it's just important to note, just in case any of you already are charitable companies and maybe are thinking of going to a scale from that. So director's duties, you can see that they're quite similar. So it's acting within powers, promoting the success of the company, exercising independent judgment, care, skill and diligence, not to accept third-party benefits, to make a certain decision, backhanders, to avoid and declare conflicts of interest. So you can see how much they mirror each other. It might have different wording, but really it's saying the same thing. And the good faith in company law is hugely prevalent as well. So I put a couple of links on here. So the Oscar one, that gives you the guidance and good practice for charity trustees. You can break it down into sections on the website, or you can download the full document. The full document is huge. It's pretty big, but you can go through it in bits, you know, and kind of take out the relevant sections for you. So the other one, governance principles.scot, that was me. I created these a few years ago. I haven't done anything with them since then, because I just don't have time or capacity, but I set out kind of principles of good governance. So I set out a few different ones, you know, integrity's in there, and you know, all these other things. So there's about 7 principles. But even if you don't want to go through all of that, there's good practice guidance on there. There's also templates for health checks and all sorts for governance. So, you know, if you're that way inclined and you want to think about kind of looking at your governance in a wider thing, that, you know, because governance goes beyond your trustee duties, it goes beyond, you know, your accounts and your reporting. It's the nuts and bolts of how you do things, and how you achieve your aims. And, you know, it's not a one size fits all kind of thing. So you just build it and put it in so that it's good practice for you and not too onerous for you as well. But there is some useful stuff on there, and it's all free to access. So yeah, fill your boots if you really want to. But Oscar would be your first port of call, and then that other one if you wanted to. There are some things that you might find to be of interest to you. So that is the end. Any last questions before I stop the recording? I'm going to put you. Okay, I'm going to stop sharing so I can see all your bonny faces. There we go. Any other questions? No, just shake your head for no. Blink once for yes. Right, I'm just going to stop the recording.